children, there's actually significant dollars to be saved. So in simple terms, if a young couple want to purchase a home at $500,000, they'll have to come up with a deposit of $100,000. Now that's a heck of a lot of money to save in anybody's book. First homeowners, and also there's a few exceptions, you don't necessarily have to be a first homeowner, but generally first homeowners are able to draw their KiwiSaver funds out and use those funds to put towards the deposit. And that's what we find the majority of young people are doing. KiwiSaver's been a fantastic kickstart for people trying to get on the property ladder. So if a couple's looking to buy $500,000, a home for $500,000 and want to come up with $100,000, they might have $60,000 in their combined KiwiSaver. They might have a further $5,000 savings, but will still be short by $35,000. So how can this be made up? Well, this is where the bank of mum and dad come in. So imagine your daughters Emma and Matt as her partner. The bank of mum and dad could simply give the couple $35,000 jointly, no strings attached. Here's a gift, good luck, go and buy your home. Or they may choose to give their daughter Emma $35,000. Or alternatively, they could provide a guarantee for the $35,000 shortfall to Emma and Matt's bank. The bank would want some security for that guarantee, such as a mortgage over your own home or a charge over a term deposit that you may have with that bank. It would have to be the same bank as your kids are borrowing through. Or you could loan the couple $35,000 interest-free. A number of the banks don't like the idea of your assistance being recorded as a loan because that's obviously an obligation, but a number of banks are quite happy if the loan documentation says that everybody agrees no repayment is required until the house is sold. So at that point, great, $35,000 is there, the house is purchased, they've got the lower interest rate because they've had the 20% deposit. So going through the different options there, I'll speak about the first couple and Paul will finish off talking about the last couple of options there. But the simple gift, so that's everybody's happy, they want to buy a house, everyone's excited, and you say, here's $35,000 for your shortfall, away you go. This should be avoided if at all possible. Why? Because people separate. And if you've given the couple the $35,000 and they separate, you don't get the money back. You may not feel too good about this if the partner of your child has been abusive, unfaithful, or something untoward has gone on. But if that $35,000 was recorded as a loan instead, upon a separation, the bank would be repaid, the house is sold, the bank's repaid, and you, just like a bank, call up your loan. You say that that $35,000 was not a gift, it was a loan. Now, the difficulty there is with the best of intentions. In a separation situation, one party might say, no, that $35,000 was a very kind gift that you gave us. There's nothing in writing. Whereas you might be saying, and your child might be saying, oh, no, 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 that was always understood, that that would be a loan and it is required to be repaid back. For a real simple solution, have it in writing. It doesn't have to be complex. We do these sorts of agreements all the time, and effectively it's almost like an IOU, saying that Matt and Emma acknowledge that they owe Ian and Sue $35,000. Simple as that. And that would mean in a separation situation, you've got that loan document that would go into the mix and you'd be repaid. And then at that point, you could choose, if you wanted to re-advance that $35,000 to your child to help them into another property. If you do wish to gift your child the $35,000, you could stipulate that you will only do that if the parties enter into a property relationship agreement, whereby they acknowledge that that gift of $35,000 is just for your child and is to remain as their separate property. These are sometimes referred to as prenup agreements. And what it would mean is that they would have a relationship property agreement that sets out what their joint property is and what their separate property is. And the gift to your child will be recorded as her separate property. If you choose to make a gift, you need to be absolutely sure you can afford it, because a gift is a gift. You can't ask for it back. And that may be difficult. As time goes on and you retire, you find that you want some money back, but your children aren't in a position to give you any of the money back. And of course, it's a gift in any event. The same really applies with a loan, which Paul will talk about. It can be a loan, but the chances of getting it back can sometimes be pretty minimal. If you also want to make a gift like that and you're concerned about qualifying as you get older for a rest home subsidy, MSD will count any gift you've made over $6,000 as still being an asset of yours, and they will treat that as your own asset when doing an asset test to see whether you are eligible. So that's another consideration that you would want to talk to us or your own lawyers about at that time. You also need to take into account, if you decide to make a gift to both of the couple or just your child, whether that is to be taken into account in your will, or if you have a trust, your memorandum of wishes. A lot of standard wills say dad gives everything to mum, mum gives everything to dad, and if you're both dead, then it's divided equally between the three kids. Well, when the divvy up comes, is the $35,000 gift to be taken into account and come off that child's particular share? Again, it needs to be in writing. So if that's in your will, you would just say divided equally between my three children, but take less $35,000 for Emma because she has already received that advance early. Another issue that you would want to take into account is whether you want to assist all of your children in the same manner and can you afford to do it. So if you're gifting one of your children $50,000 and you've got three other children, chances are they would expect that to receive the same gift, or even if it's a loan. If it's a loan, you probably should proceed on the basis that there's no guarantee you will be repaid.